All right, we're back. Okay, so on the certificate of service also includes the service information. Okay, there's a little statement right here below my list of things. Actually, I'll just read the thing to you because it's a very short one. The heading, Notary Certificate of Service. It is hereby certified that on the date noted below, the undersigned notary public mailed to, name and address of who it's going to, hereinafter recipient, the documents and sundry papers pertaining to a certain account number, 123, regarding Barney F. Rubble as follows. Item number 1, notice of default dated on or about November 6, 2008. Item number 2, reference copy of this notary certificate of service, signed original on file. By registered mail number, and it lists the registered mail number, return receipt, attached by placing same in a postpaid envelope properly addressed to recipient and at the said address and depositing same at an official depository under the exclusive face and custody of the United States Postal Service within the state of California. So, again, it's an affidavit. It is certified that documents were mailed to this person, name the recipient regarding this, these are what got mailed, and here's the number, the tracking number for it. So, what I like to call a complete claim is not only will it have your certificate of protest, which is this document here, it'll have a certificate of protest, it will have all the supporting documents, so it will have your original affidavit, your original certificate of service of the original presentment, maybe your notary presentment letter, the notice of default, the certificate of service for the notice of default, okay? All of those documents together along with certified copies of my return receipt, which is Form 3811 from United States Postal Service, and my registered mail receipt, Form 3806. Okay? So it would include all of that. And then I would slap an apostille on top of it, or a certification from the Secretary of State, making it a self-authenticating claim. Okay? So all of that evidence together is, now if I wanted to, with all of those documents, what does that comprise? If I've got all of those documents together as one packet, what does that comprise, you think? Not only a claim, but I have a third-party witness to every element of the claim. If I have a third-party witness to the entire claim, isn't it essentially a judgment? And if we go into administrative procedures under the code of under Title V, you'll see that that's what they're doing to you. It's not that the bank has any claim on your house. It's that they get you involved in a commercial process where you default on the commercial process. That's how they establish the claim. And every time you receive something new in the mail, it's a new offer. A new claim is being established. Whether it's a notice of lien, notice of levy, even your mortgage statement. It's an offer. Don't they give you so many days to respond? When you don't respond, don't they take some other further action? Okay? So this administrative procedure that we just discussed of going from A to B, it's going on in B all day long, every day. It's just their records are all standardized forms, standardized documents, standardized formats. Remember when we talked about jurisdiction A and B in form and substance? Everything in B, the democracy, is form. There is no substance. Everything in A is substance. So when the IRS perfects their lien against you, doesn't the IRS get to sit on the fence between these two jurisdictions? Maybe that's why they don't have to show you their claim. Whereas a bank's administrative procedure, typically, they'll show you the claim. Not always. Sometimes they'll just bring an invoice.
I'm going back a little bit from what you just said, but the process that you just described, at what point does it go into jurisdiction B? Because from what I was looking at, you were still in the private. Is it when you put the apostilles into the Secretary of State? Does that...
Well, it's still private. Even after I've gotten the apostille and the certification and everything, it's still a private claim.
Okay.
Okay?
So we haven't even gone into
No.
B yet.
Yeah, because I could take that entire claim and put it with a new presentment letter, and that one I would call presentment of evidence under notary seal, and I can bring it into a jurisdiction B court and get a judicial review of my evidence, and then get some writ out of the court based on a judicial review of my private evidence, private proprietary evidence. And I would, in my letter for that, I should have included one of those, because I've done those before, and I do have already prepared notary letters for submitting evidence. And the way that you structure it is you're clear that it's private proprietary documents. That if the judge or the clerk were to put these documents into the public, it would be harming your private rights. Okay? It is a private proprietary process. That's why it must go in under notary seal into judges' chambers. Judges' chambers is the private side of a court. Okay? If it doesn't go in under notary seal into judges' chambers, you could lose it to jurisdiction B, and they would then have title to your claim. Can you pass that back?
That seems to be bringing up an important point, and that is, let's say you had some form of information that you did not want put into the public record. In order, let me rephrase that. To prevent someone from bringing it into a public forum, i.e., or e.g. a lawsuit, you would put private on that document. Then they can't use those documents in a court of law against you.
Yep. I have a couple stamps. I have one that just says private. I stamp that a lot on things like the envelope. My registered mail envelope will typically have a red private stamp on it. I also have a red stamp that says private. I think it just says private, not for public filing. And I typically stamp that on anything I'm sending into the court on the private side. And it's funny because I actually got a call from a clerk. I'd gotten my evidence into a court case, into chambers, and I was going to attempt to use it, but I had created a civil case where I didn't have any statutory, I wasn't doing anything in accordance with statutes, so I kind of basically, I separated myself from my remedy. So I created a case over here, and my remedy was over here, and I couldn't bring them together. Okay? Now, after the case, a couple weeks later, the clerk calls me. And she goes, Mr. Adams, we have these documents here that are stamped private, not for public filing. Would you like to come pick these up? Because we can't file them into the case. But the judge held them for 4 months until then.
120 days.
Well, I'm actually estimating, but basically the judge held them from the time he had those documents from the moment I started the case. But he didn't release them until we were done with the case. And then, because I put on there that this is my private proprietary evidence, oh great, this is going to turn into something fun. So because I had put on there that it was my private proprietary evidence, the judge did not put it into the public record. And then he held on to it because in the notary's presentment of evidence under notary seal, it states that this is to be held as evidence, that there's going to be public filings that call upon this private evidence. And the private evidence had the apostille and everything on it, so it was a self-authenticated judgment. But because I created a civil case over here in B, there's no foundation for me to get a judgment from A over here into a civil case in B. I would have to take that judgment from A and bring it into B under judicial review or adjudication. Okay? Because I'm seeking an order or a writ, not necessarily a benefit privilege of filing a civil case. Go ahead.
Brandon, can you explain how you can traverse into B and get the public to recognize the Jurisdiction A document to enforce a commercial claim in the public when it originated in the private?
Okay. Records. Okay? If I've got a claim against Bill, my private claim, okay? Let's say on my affidavit, I said something to the effect of, if you don't respond or pay me within 10 days, you're agreeing that I can file a UCC1 filing on you as the debtor. You're agreeing to that. So, Bob doesn't respond. I now go into Jurisdiction B and file a document there known as a UCC1. I list Bob as the debtor, me as the secured party, and the collateral, whatever I want to list on the collateral, or whatever Bob agreed to in the affidavit. I may say in the affidavit, and you agree that your house is going to be collateral on that claim. And then I go file it in the county. I've now got a UCC1 claim against Bob in the county with his property listed as collateral. What can I do? I could foreclose on him for that $1,000 debt. Because of the public record, though. Not because of my claim. This claim never makes it over here. I don't attach this to my UCC1. UCC1 is just a notice. But remember, in Jurisdiction B, what matters? Form. They don't want your substance. Leave that over there. It's all about form. So that simple document recorded into the county is all I need. Now, if he tries to challenge my lien, what's the only way he can remove that lien? Besides that, let's say he doesn't want to satisfy it and he wants to challenge it. He would have to actually get a jury to remove it. And guess what? And guess what happens? When he takes it to court, what am I going to send into judges' chambers? My claim from Jurisdiction A. My private evidence. And no matter what Bob says in the court, it ain't going to go over my claim. Because whatever he says over here is going to be what? Hearsay. He's not going to bring any evidence in under the rules of evidence that can contradict my evidence. And my evidence, if I presented it under notary seal, it's self-authenticating with the notary seals and the Secretary of State certification on it. It is a, what's the word I'm looking for? It's not superior. It's a, oh my God, I can't believe I'm totally blanking out on the word. No. No. It's... No. Stop. I know. It's an exception. It falls under exceptions to the hearsay rule. Okay? Because it is a claim, right? Right? Isn't my certificate of protest just an affidavit by the notary? Well, how come her affidavit has more weight than Bob's affidavit? Not only is she the witness, but it is her duty to keep that record. And if you look under the exemptions or exceptions to the hearsay rule, if that record is a record that is part of some third party's record-keeping process, or their official record-keeping process, you can bring that in, and it would be an exception to the hearsay rule. But Bob doesn't have anything like that. So anything Bob brings into the court is going to be hearsay.
What if Bob was a creditor?
What does that mean?
One did put a claim together like you did, so then the court again.
Oh, so we're going to have a paper battle? First one to leave the battlefield first loses.
So a recontract, you would just be in acceptance and
Of course. Anything Bob says to me, I'll accept.
does the jury see the private evidence?
No.
So
But who really makes the law in a court? The judge.
He's already in default, though. There's nothing you can do.
Right. Not only that, I've got a UCC1 claim on him, and I've got the evidence over here to back it up. So the judge is going to basically instruct the jury, you will not overturn that UCC1, because all Bob has done is give us a bunch of hearsay. And hearsay doesn't refute the facts. See, my UCC1 stands as fact because of the evidence that supports it. Okay? Yeah.
So let's say that Bank of America goes into default, and I have my stipulation that their executive headquarters in North Carolina now becomes collateral. I can file a UCC1 in that state,
Yep.
put a lien essentially on their entire headquarters building and foreclose on them. That's power.
Yeah. Not only that, let's say you have a claim against Chrysler.
Right.
You show up at the docks with your claim and say, these cars that you're unloading, keep them here. I'm seizing these vehicles. Okay?
that's what the IRS would do.
Yeah.
Or any other.
Go seize it. Bond the sheriff. Have him go seize it. For like $500, or it depends on what the sheriff's seizing, but typically for $500, you can get the sheriff to go seize any property you want. He just needs your claim. How do you show the sheriff your claim? What do you show him? Your UCC1. Because he's in the public. All he needs is form. You just need to show him a public record and then bond him. And he's going to do whatever you tell him to do. Well, within the guidelines of the administrative laws.
Resulting of what comes out of the court?
What?
It wouldn't be what results come out of the court instead of the UCC1? Or whatever.
There wasn't, no, because he brought me to court. He tried to challenge it. The results were I won. I don't need to stand on that claim. Now, if I wanted, I could go file a court case on my claim, and I can get a judgment lien. And there's actually a special form from the Secretary of State just for a judgment lien. And it's even got a dollar amount on it and a signature line. That may even be more powerful than your UCC1, as a claim in the public, I mean, because it's got the dollar amount on it. Well, typically your UCC1 will also have the dollar amount if you're smart, but it's got a signature line on it. And the national forms, the UCC1 doesn't actually have a signature line. It's not a verified claim, but the judgment lien is a verified claim.
So right after you win that battle, then you could go back and...
Yeah, I could go to court. I could start a process here in B, because what am I going to do? I'm going into B to enforce my judgment that I got in A. Okay, I acquired the judgment over here, so I can bring it into B. That's tricky, doing that process. I know from experience, trying to get what you have over here recognized over here and get the result you think you want.
Is that judgment lien that you just mentioned, is that enforceable in B without a court case?
No. Judgment lien, you can only fill out the judgment lien form if a court case led to the document.
There was a guy in Washington, I think, was working for Boeing and had some issues with the IRS coming after his wages, and so then he went and put a lien on all the Boeing facilities and everything else and a bunch of stuff, but he got in trouble he kept doing it and they finally, had to pull the liens off. Judge pulled the liens off, and then he kept doing it. Him and his wife kept finding all these things. They finally
Yeah, and what was wrong with that? What was he doing wrong?
I don't think he was following the full process. He was,
Yeah, he was just filing liens.
yeah, yeah.
So if you file a lien and you don't have something over here to back it up, not only is your lien not going to hold water, but you could probably end up in jail.
Yeah.
You put a lien on an IRS agent, a judge, something like that, and you don't have something over here to back it up. You got something over here to back it up, you can lien up anyone. You can lien up the President of the United States if you got something to back it up. If you don't have something to back it up, I wouldn't put a lien on anything or anyone. This must come before this. You must have the substance before you can put it into form. If you don't rebut their claim and you default on it or don't respond to it, their claim stands. Okay? So if no notification is given, how can it be a claim? They have, a claim could be an invoice. Okay? We're talking about jurisdiction B over here. Okay? So if they've got QuickBooks, they could create a claim. If they've got Excel, they can create a claim. If they've got Word, they can create a claim. Just no, what I'm saying is there's no guidelines for that. If you're keeping the thorough records, like an invoice will only take them so far. If you're challenging it and you're challenging the validity and you've got evidence that contradicts their statements, then their evidence falls apart because they won't even sign it. They won't even verify it. They won't even sign under penalty of perjury that you owe that money. Not even with your house. They won't sign a verified statement saying, yeah, we loaned him money. Yeah, right. They'd be committing fraud. So they won't do that. So if nobody in the public is going to sign their name to anything to make a claim against you, who's got all the power? Yeah, you've got all the power. Remember we were talking about when you truly understand how to be responsible in commerce, you hold everyone to task. You think there's a corrupt person here or a corrupt person there in the government? Perfect a process. And you can get rid of them like that. Because once you get your claim and you get your record and you attach that to their bond, they're gone. And they'll never work for the government again. They'll never get insured. See, every public official must be what? Bonded. Bonding is like insurance. I perfect a $10 million claim against some corrupt official, and I liquidate that claim on their bond. What insurance company will ever bond that guy to work in that position ever again? No one, because nobody wants to lose $10 million. It's like if you had car insurance and your policy was actually $10 million and you were consistently getting $10 million claims against you, but you were only paying a couple $100s a month. You think that insurance company is going to keep you on as a customer? No, they won't bond you anymore. They won't insure you anymore. Like, no way, forget it. What about health insurance? If you have a pre-existing condition, do they bond you? Do they insure you? No, it's loss. They're not in it. They're not in it to lose money. So it's the same with public officials. The bonding companies are in it to make money. You know, and the public officials, they don't pay a whole lot for those bonds. So I guarantee you, you get a couple multi-million-dollar claims against your bond, you ain't gonna work again.
Brandon, I'd heard that it takes 3 claims against a bond for them to drop you, but my question is, do you have to go to the county recorder to get a copy of the bond to find out what the number is?
You could do a commercial process to get that. If I made presentment to an attorney, and I put on there that I have a claim, and that she has 10 days to get me her the bond, whoever holds her bond, you know, what do they call that? Well, besides the bar, gosh, I'm totally lost for words tonight. Anyways, if you do a presentment on them, they don't respond, you've now got a claim on that bond information. You could actually now take it and get an order out of a court ordering her to supply you with that information.
What would be the damages, or how could you, they don't respond to the court order, then what? Did you have to stipulate that in your original process? If you do not...
They don't, well, then now they're in contempt of court. Does anyone here know all crimes are commercial? Did you know that? Yeah. Everything is commercial? What's the one thing you can go to jail for? Because when all crimes are commercial, even what you think are crimes, it's commercial. So there's only one thing you go to jail for. Does anyone know what it is? Contempt of court. That's the only thing you can go to jail for. In admiralty. Aren't we in admiralty? Okay. Well, in admiralty court, the only thing you can go to jail for is contempt. And when you plead not guilty, you're instantly in contempt. Yeah. Run that one through your noodle. Because not guilty is, well, first you stood up and you said you understood the charges. You're saying, I'm going to be surety for these charges. Right? Right. You said you understood, so you said you're surety. Now, when they ask how you're going to plead, how are you going to pay, and you say, I'm not paying, you're in contempt. You say, guilty, gilded, pay, I will pay. I plead guilty to the facts, Your Honor. I want to effect payment immediately. What's the sum certain on those penal sums? Done deal. It's all commercial. There's some questions in the front, you guys, too, so try to pass it up when you get a chance.
There was chatter online that due to California's credit rating lately, that the bonds for new court cases are not being purchased in the international market, and that now the prisoners are running out of food because there's not enough funds from their jail situation, and that if they can't get those things purchased in the future, they're going to start dropping cases and letting people out.
Interesting. So our bonds, our prison bonds, aren't worth what they used to be, I guess. You know why? I guess the population's probably gotten too high. Realistically, because it's all about production. If these inmates aren't creating enough production and a future value on those securities, nobody's going to carry the securities. They're not making the license plates. They're not making the computer chips. You know, if they're not doing those things, or there's too many of them to actually get enough work done, yeah, you'll start to see them dropping people out of jail.
Look how we house them. Look what they do in Arizona. They put them in a tent city.
Mm-hmm. Which, the funny thing is, those bonds probably sell for a lot, because he keeps his overhead so low. The guy in Arizona, the tent city, keeps his overhead low, so his bonds are probably worth more than the state-of-the-art prison facility.
You mentioned apostille from the state Secretary of State.
Yeah,
Can you
and
just briefly tell us a little bit about what that is?
Yeah, an apostille is a certification. It's basically all that an apostille is doing. It's the Secretary of State saying, yeah, that notary public is, that signature and that seal are a legitimate notary public signature and seal. So having the apostille on top of your document is saying that the Secretary of State is saying, all the Secretary of State is testifying to is that the information is accurate, that the notary signature and the notary seal is a valid notary, but the notary witnessed an event and swore to that event. So when the apostille or the certification is attached to the notary's testimony, you now have a self-authenticated document, because an apostille or certification can be sent to any nation on the planet, and it is recognized as a legal document. Okay? The Secretary of State. Yeah, and if you're actually doing it in the United States, like if I'm not sending it from one, like if I were to make my claim from B to A, I can get an apostille. Okay? I can't get an apostille from A to B because they don't necessarily operate in A, or at least the Hague Convention wasn't made with jurisdiction A. The Hague Convention, which is the agreement that all the nations agreed to certify documents this special way so that they would be acceptable all over the world, that's the apostille process. That's the Convention de la Hague. Jurisdiction A doesn't necessarily have anything to do with that, but check this out. I could actually, so an apostille is from one jurisdiction to a foreign jurisdiction. If it's from the state of California to the state of Nevada, it's actually a certification. If it's from the California Republic to Nevada State, it would be an apostille. But who's going to apostille something from the California Republic when the Secretary of State's probably operating over here most of the time? Okay, or at least that's the Convention de la Hague was over there. Now, you may be able to get them to apostille something from a republic state to another republic state, but typically what you're going to get, rather than an apostille, if it's being done within the United States, is you're going to get what's called a certification, which is basically an apostille, but apostille is the international term. So if you go to the Secretary of State and go, yeah, I want to get this apostille, do you know what she's going to ask you? For what country? What country are you sending it to?
So you would get an apostille if you were just submitting it as documents in a court locally. You just get a certification.
Yeah, you would get a certification. Exactly.
What does that cost?
About $20 per document. Yeah, I think I get them for about 20, but I walk them in. I actually drive up to Sacramento and walk mine in.
There's an extra fee for that, but I think by mail it was like 10 or 15.
Yeah, it's actually $6 more, but I get mine right away. They literally take it over the counter, apostille them, and hand them back. So there's no 10-day waiting, 14 days waiting, or nothing like that.
Don't they do that downtown LA?
No. If you go to the county, you could get it done in LA, but this is the process. Okay? See, I can take just my notarized document directly to Secretary of State, and I get an apostille. If I wanted to do it at a Secretary of State field office that's not in Sacramento, I would first have to take it to the county that my notary is commissioned in, and I would have to get certification from the county on her signature. Then I would take that to the field office for the Secretary of State, and the Secretary of State would give me an apostille on that.
That was my question, actually. How do you do certification?
Certification is the apostille process. It's basically when you go up to the Secretary of State window, you say, I want an apostille if it's going to a foreign jurisdiction. If not, I want certification. It's the same exact process, costs the same amount of money. If you ask for an apostille, they're just going to ask you, what country? That's the only difference in the process, what country.
So what we were talking about earlier when we were talking about getting a judgment, so let's say you took it into court, we really wouldn't have the apostille, it would be the certification, because it's
Right.
from state to state.
Yeah,